Hello and welcome to a Nautical Institute book launch webinar on expert witnesses. And I am joined here by this wonderful panel from around the world who you will be introduced to in due time. I am confident that you all know the Nautical Institute, but if not, we are an international professional body. We share ideas amongst ourselves, with our community, with the idea that those ideas will all help us make better decisions, and that's what we're about. We're now going to talk today about expert witnesses, how they make their decisions, what they do, because expert witnesses make a big difference in our industry. So just before I introduce everybody, this is an interactive webinar. Your cameras and your microphones will not work, but you can write in your questions. So please write in your questions, hit the little send button, and they will come to us, and we'll try to get to as many as possible. After the webinar, there will be a little pop-up survey. It will only take a minute or two so that we can know how we've done, so we can do improvements as we usually do. After the webinar ends, probably 2 hours after the webinar ends, you will get an email saying thank you very much for attending. There will be some details on how to order the book, and you will have a link to a personalized certificate for your CPD records. So you're welcome to that, but it'll be just a couple hours after the webinar ends. This is being recorded, and that recording will be made publicly available on the Nautical Institute's YouTube channel, but please leave it till probably late tomorrow to look for that, and then feel free to share it with your friends and colleagues. You are not alone. There are probably now over 800 of you out there interested in this wonderful subject of expert witnesses. So if you do write in, if you can be as concise as possible, we'll get to your questions. So now it is my great pleasure to hand over the proceedings of this to Bridget Hogan and Captain John Noble. Bridget is the newly retired but former head of publications at the Nautical Institute. And if there are anybody in the industry anywhere in the world that does not know Bridget, I will be surprised. John is almost as popular, with a long career in shipping, expert witness, casualty, and a fountain of knowledge. So Captain Noble, Bridget, over to you.
Thank you very much, David, and good day to everybody and welcome. It's a very big day for us to be launching the Expert Witness Group. I'll take you back a little bit to the whole context around which this book is published. You will already probably be familiar with our evidence guidelines series. Now, we know that people are very concerned about the correct way to collect evidence, because increasingly there is a lot of legal action around incidents, and there's a lot of money at stake, plus as well as a lot of blame if we're not careful, although we're always trying to get away from a blame culture. So these books set out how you can go about the best practice, the best ways to collect evidence. But how does that get used? Because once you know how that gets used, it helps you to understand why you're being asked to collect evidence in a certain way. In addition, many of you may well be interested in becoming expert witnesses. And although these days training is available, and we will speak about that, usually it's not so much a career move as something that happens to people. They are called to account to give their expert opinion on something because of their big experience and their backgrounds. So having published these 2 volumes, we set about thinking how we could help people further. And we called in John Noble, who had already been the technical editor guiding through these publications, to help with our 3rd publication. And before I ask John to introduce the main substance of today, which is our expert panels talking about the subject, I think, David Pacheco, it would be nice if we could conduct our first poll, please.
Okay, here we go. So this is the poll. Have you ever been an expert witness? So if you could please choose yes or no and hit the submit button, that'll give us a nice starting point for this event.
Ask for the result of that. Introduce the panel.
Okay, Bridget, let me just
Thank
share.
you very much.
Let me
Thank
just
you very
share
much.
the results of that. So there we have it. 39% have said yes and 61% no. So you've got a very educated crowd out there.
Yes, indeed, but very educated, and also we know that there are some people out there who would like to know more.
Thank you, Bridget. Well, good day, everyone. It is a pleasure for me to be here. And Bridget introduced the guidelines for collecting maritime evidence for a witness. You'll note when you see the book, it's actually the 2nd edition. And I think it is worth me just reminding you that there was a 1st edition by Captain Mike Bozier in Australia. And it was his short monograph that persuaded me that we should bring the topic back up to date. Now, what I'm going to do is look a little bit at the groundwork for the guidelines for the maritime expert witness, because people like me, David Pocket and a few others who I can see on the screen, probably never had any guidelines about being an expert witness. We were thrown in at the deep end and left to the counsel and cross-examining counsel to make what they could of us. And I can honestly say that on one occasion I was truly crucified. And as a result, the fact that expert witnesses are now properly trained is, I think, an excellent progress. I won't go into the detail of why I was crucified, because it would not pass the censor. But I would also like to thank all the contributors. We have on our panel today a few of the contributors to the book, but there are also others who could not make it today, and also time was not on our side. But I would also like to thank Sir Julian Flo, who did the introduction. Sir Julian is now the Chancellor of the High Court, and he made some fairly flattering comments, and it made me slightly humbled that he had actually taken time. Now, what we're going to do is I'm going to introduce the panel one at a time in some sort of order, and ask them to say, we're not trying to plug the book does that itself, but we do want to plug or address the key messages that are behind the book and why we've got a huge experience on the panel here today. And this is something I think that will be reflected in the many people watching this and listening to this, because it will help them make a decision about being an expert, getting training to be an expert, making sure they know which organisations are there. So without further ado, I'm going to hand the screen, if that's the right word, over to Captain David Pocket. Before I finally hand over to him, David and I go back an awful long way, 1964 to be precise, and our paths have intertwined over the years, and he's a gentleman I have the utmost respect for, and I was really pleased that he agreed, A, to contribute, and B, talk to us today. David.
Hello, good morning everybody. Thank you so much, John, for that very kind introduction. So thanks to the Nautical Institute, and in particular to Bridget and John for being able to get this wonderful document published. I know what it's like to be technical editor, having done it before. There's a lot of work involved, a lot of coordination required. So all thanks and congratulations to you both. As John said earlier on, I was thrown in at the deep end. I mean, I gave my first expert evidence I think in 1979, 1980, and I think it was in the Guilds Church of St. Catherine's in Leadenhall Street, of all places, where I can only remember the counsel for our side was Bernard Eder, who's now Sir Bernard Eder, I believe. And it was a chemical tanker case, and I happened to have been master for a brief period on a chemical tanker. And the case involved a ship almost identical in design to the last one I was in command of. So it sort of fitted, but it was a phone call from a law firm or a club, I can't remember now. But that's how it happened. You were sort of thrown in at the deep end. We didn't have the excellent services of Solon to give us training in those days. And you were more or less prepped by the solicitor and or the barrister when you went for a conference with counsel at chambers. But be that as it may, the prepping was very good. So there's no criticism at all of the legal profession in that regard. They were very good in sort of setting the scene. But you can never set the scene when you're actually there in the witness box, as everyone and the 39% of people who have responded to the poll will agree. It is different, and you do get people who say, "Oh, I've never been seasick." Well, yes, I don't believe it, or never felt seasick, I should say, or you've never felt nervous. You do. And a very, very well-known QC said to me, "If you're not feeling nervous, then something is not quite right because you're overconfident." So I'm always nervous in that regard. And I've been thrown in at the deep end for the first year or two because that's the way it went. Because being an expert witness, in my opinion, is not a career. It's not something you should have after your name. It appears in your CV that you've given expert evidence. But it's rather like a special casualty representative. You can't take a career in that. There's only about 10% on the list ever used. And in expert witness cases, there's frequently a beauty parade because a law firm will know that A, B, C, D, and E have experience in, should we say, mobile offshore drilling unit moves, rig moving as we call it, but in actual fact, only one or two might suit that particular case. And it really depends. It's a personality thing as well as expertise. And to be fair, there's an awful lot of people who are probably far better in what expertise they have than some of us who've given evidence. It's just that it doesn't fit their bill to be able to speak, or they're not so good on their feet, but they're extremely good with their knowledge and on paper. So it's not all wine and roses either, being an expert witness, because once you are involved in these large cases, as many of you will know, is that you have to be pretty dedicated to those cases. There are case schedules to keep to. You can't sort of play around with the tribunals or courts. You have to sort of keep to those schedules. You have to turn down other work if they clash. And in actual fact, when you actually are on a long case, I mean, it takes an awful lot of your time up. And if you've got other work, such as in my case, running a company or a group of companies, or you've got other cases to get involved with, there's a very important sort of prioritization that has to take place during the course of a case. But the other thing I found out, and there's one case that I particularly remember, and I'm not going to sort of swing the lamp here, but I do remember acting in a court once in a personal injury case with a poor able seaman who had his leg crushed by a moving pile on the back of a supply boat in the North Sea. And I remember it very well because I was taking an Open University exam that afternoon and I was giving evidence in the morning. And when I was giving evidence, before we started, I was introduced by counsel, and the judge, his lordship, said, Miss Hobday, before you commence, I don't see the word piles in witnesses' curriculum vitae. And blow me, there wasn't the word piles. There was an awful lot of talk about pipelines, but not piles. Well, of course, most of you will know that pipelines and piles are similar in shape. There are structural differences such as wall thickness and weight and things like that. But we spent about 15 minutes with me trying to explain to his lordship that the actual handling of this pile and the pipelines and the securing of them was in actual fact very similar. But I felt as if I wanted to fall into a hole because the judge was extremely upset the fact that the word pile didn't appear in my CV. And I've remembered that for the rest of my life, that if you're going to put a CV forward and it's something upon which you're giving evidence, which sounds rather obvious, you should actually make sure that you have the word pile. I mean, I had hemorrhoids after that case, I can assure you, but you really have to put down everything that you're going to address. So as I say, it's not all wine and roses. It's not a career. It's not something where you put expert witness after your name. It's an honour and a privilege to be an expert witness, and it's wonderful if you're on the winning side. And it's always nice to know that if you've got a bad case, you rely on the law, or what is it? I think they say in the States, and if you've got a good case, you rely on the facts, and if you've got a bad case, you rely on the law. But expert evidence can be so important in deciding a case. And that's all I have to say, John and Bridget.
Thank you very much indeed, David, for that most useful input. Excuse me. I'm now going to ask Jonathan Lutz to say a few words. Jonathan, I've known for many, many years, and I've held him in very high regard. I'm not going to read out his CV. The fact that he's here is dedication itself to his own professional background, and it was a great privilege when he agreed to contribute to the book. So, Jonathan, can I ask you perhaps to address us for a few minutes?
Thank you, John. And apologies right at the beginning. I'm afraid I have a slight sore throat. But I assure you, more painful for you than it is for me. So apologies in advance. The National Institute guidelines for the maritime witness is an excellent initiative with which I'm delighted to be associated. And I would like to thank Captain John Noble, Bridget, Vivian, and the rest of the team at the Nautical Institute for spearheading this. Now, legal disputes are inevitable in the world of shipping and international trade, but there is a choice for the parties. I'm hearing a certain amount of music in the background. I don't know whether it's my microphone or someone else's, but it might be an idea if everyone, apart from John and myself, John, Bridget and myself, mute their devices. That may help. Thank you very much. So I was saying that legal disputes are inevitable in the world of shipping and international trade, but the parties have a choice in terms of how they deal with disputes. The traditional means of dispute resolution of court and arbitration are adjudicated. So the parties present their arguments and the judge or arbitrator decides. But there are also non-adjudicative processes, and the most popular by far of those is mediation. The mediator counterintuitively, the mediator makes no decision, but aims to facilitate a resolution by the parties. And despite the lack of coercive powers of the mediator, the available evidence indicates that approaching 90% of mediations are successful, success being defined in terms of settlements achieved. Now, the role of the expert witness is very different in the two different types of processes. The adjudicative process in court, the facilitative process in mediation. In the former, so in court or arbitration proceedings, the expert is there to lend support to the legal position advanced by the client. For example, that the vessel was or was not unseaworthy, that the cargo was or was not properly stowed, etc., whatever the specific issue may be. In mediation, on the other hand, the expert is there to work with the party to identify his wider interests, and that is likely to lead to a more wide-ranging inquiry and analysis. Therefore, I will suggest to you, and I wouldn't I, that mediation is not only good for the parties, because in most cases it leads to a settlement, but is also good for the expert because it involves a more wide-ranging brief. Thank you for that. I'll be happy to expand on any points during question time. Thanks for your attention.
Thank you very much, Jonathan, for that very erudite presentation, even if the frog got in the way. Can I now turn to Mark Sullivan? It's worth thinking about taking a ship to sea with an untrained crew on board and going through either the Dover Strait or the Singapore Straits with a trained crew or with an untrained crew. Think about that, because giving expert evidence in the current regimes, as it were, training is becoming increasingly important. So I'm going to now ask Mark if he would just give us a few minutes of his infinite wisdom on that topic. Thank you, Mark.
Well, I just tell you a personal experience. I was involved in quite a major piece of litigation, and we had an expert witness who was extremely good, you know, at the meetings and preparing his report. But when we got to the courtroom, it was a complete disaster. The papers flying around the court. He was throwing about the cross-examination, and I was at the back going, "Oh my God, what's going on here?" So after that, that was a sort of turning point when I thought, why are some witnesses able to give cogent, clear evidence that is understandable, and others just collapse, even though they know the actual matter in dispute? And so I started to notice what makes the difference between a witness who's in control and the witness who isn't. And so originally I developed these programs for, which we used to call courtroom skills, about how to give evidence in court. And then as we developed that, it became clear that a lot of experts hadn't got a clue how to write a court compliant report, because as you probably know, there's lots of ins and outs about how to structure a report. And so we started training on how to write a report. And then it became clear that a lot of them hadn't got a clue about the law and procedure involved, and the protocols and the practice directions, the whole thing. So we started training on how to understand the court procedures and arbitration procedures. And then it became clear that it's all very well going on a course, but you need to have some sort of assessment to give comfort to the instructing solicitor. So we worked with various universities to assess people's work. So we would train, and the university would assess their reports, assess their cross-examination, and assess their knowledge of law and procedure. And so these programs have been developed over the last 20 or so years. And I suppose the message that I would get across from the book is you can't be an amateur expert. There are two skill sets. There's a skill set about being the master of a vessel, and then there's a skill set about how to give evidence relating to your knowledge. So you've got the qualifications and experience from your day job, if you like, but being an expert witness is a second skill set, and that's really important. So that's why I say we shouldn't be amateur experts. If you're going to go into this, I know 60% of you or 61% of you haven't ever done this. Don't go into this unless you're fully prepared. There was a case a few years ago called Jones and Caney, which says that you are actually liable for the opinion that you proffer. So you can be liable both in contract with the solicitor and in negligence for the opinion given. So you need to know what you're doing. There is a process about being an expert that you need to know about, because otherwise you will get the proverbial mauling. The problem really for solicitors is that if they have to handhold you because you don't know what you're doing, there's always the potential inference that they've interfered with the opinion. And of course, your opinion must be independent. Your role there actually is not to win the case or be on the side of the people paying you, but a rather schizophrenic role that you are there to assist the court or the arbitrator to understand some technical issue. And so sometimes there's a little bit of conflict between the solicitor and the expert as to the opinion you come up with. Now, of course, we've heard a little earlier about CVs and acute medical conditions around piles, etc. But what we the solicitors will actually go through the other side's expert's CV in great detail, looking at what you've done, what your experience is, because the first line of attack will be, well, you're not the right expert for the issue in dispute. So you need to know how to construct an expert witness report, an expert witness CV. It's not you're swimming the witness certificate. It's about what you've done in your professional field, because funny enough, the expert is issue specific. Because what a lot of experts also aren't aware of is that their duty is to help the court or the arbitrator or the mediator to understand some technical issue. And so it's not about trying to impress them with your knowledge. It's almost an educational role to help them understand some technical issue. If it was not necessary, you wouldn't be there. So that is your role. So I think that's about all I want to say at the moment, John. We're happy to take questions, but I think the point, I repeat the point, and emphasise what John said, don't be an amateur expert. If you're going to get into this field, I know a lot of you already 40%, 39% are. If you're going to get into it, you need to do some proper research, get yourself trained. Thank you very much.
Thank you very much, Mark. I'm just wondering if Jeffrey is around, because I don't see him on our screen here.
I don't think he's with us, John. Stand by. We'll contact him. Maybe you can move on.
Okay. Well, what we'll do, to keep going, we'll take our next panel member, who is particularly well known to me, Captain Zarir Irani. And you will notice that Zarir is not a contributor to the book, but his presence at this opening is very important, because the aim of the book is to help people who have not perhaps got as much experience in the witness box as others. So on that note, I will ask Captain Zarir Irani, who is sitting in the sunshine in Dubai playing golf, to perhaps address us for a few minutes. Zarir.
Thank you very much, John, for having me amongst the esteemed panelists. And like the previous two books, I had a glimpse that this book is excellent as well. And thank you for inviting me to speak about what it takes to be an expert. And as David Crockett said earlier, I was a victim of exactly what he said, being dragged into it because of me being an independent surveyor. And here Mark Sloan loud and clear, it's rather that we get ourselves trained into it, because after spending 30 years with the maritime industry, of which 17 and a half have been as an independent surveyor, I am pretty sure that it is going to be sooner or later that more and more such expert witness work comes upon to an independent marine surveyor. Those amongst the audience of 405 that we are having today are contemplating whether or not they want to build this as a career. I feel that if you've been long enough doing what you're doing, you will be sooner or later being called in to give expert opinion, provided you have the independence, provided you have the reputation, and you can take a few bullets on your chest, like I was. And recalling my first experience of the few that I've had in the Middle East, I was asked where my real CV was, because as Mark said, you always make out a CV which is relevant to the case, and you put down all your experience which come up to make whoever's reading understand what you're saying is coming out of all the years of experience. But they wanted to know where else and what else have I done. And it's very easy these days to find who you are and what else you do in your daytime jobs. And LinkedIn profiles and website profiles was a common answer. But the one that was submitted was far different and was a very selective CV with experience in it. So what I'm saying is, nervousness is the protocol. You got to go down with a bit of a loose belt, so to say, so that if your pants get pulled down, you're not too uncomfortable while that's being done. But that's not going to be for too long, and every now and then it is something that comes your way. In the Middle East, coming to regional aspect of it, experts are in Dubai courts or UAE courts requiring to speak Arabic, read and write Arabic frequently, as them having a mandatory requirement to be listed amongst the expert panel. I unfortunately can't do either. I can only understand a little bit of Arabic. Embarrassingly so, being here for 17 and a half years, I should have had a better grip on the language. But Abu Dhabi Courts of Appeal have a different agenda. They are, in fact, they've made a lot of local language, including my native language, Hindi, as one of the acceptable court languages in Abu Dhabi. So they are a bit liberal compared to other UAE courts. The maritime law in UAE is pre-drafted and is up first being signed by the 7 Emirates. So I had the privilege of putting down an expert opinion for the Abu Dhabi Courts of Appeal in English, along with other experts which were jointly having their view on the particular case matter. And that was in English, although I was told to have an Arabic translator next to me, so in case the other experts were discussing something in Arabic, I would be able to pick it up without interrupting, which I did. So it's a bit of a regional peculiarity here. And the other thing is, most opinions, almost all opinions in the UAE are written down and submitted to the court. And the questions are put down as to what clarity the court expects out of experts, and we have to answer exactly to those questions. And that's how our region operates where expert witness is concerned. But I'm open to questions, and from me, this is all there is from our side of the world where expert witness work is concerned. Thank you very much.
Thank you very much, Captain Zarir Irani. We'll now get back on track with Jeffrey, I see, who's come back into the division. Jeffrey, I'll ask you just to introduce your own background, because I know it's very pertinent to the whole role of the expert witness. Bear in mind, we've got one speaker after you, then questions. I'll ask you to be as brief and concise as you feel possible. Over to you, Jeffrey Blunt. Have we lost him?
Jeffrey, can you make sure that you're unmuted, please?
I am unmuted. Can you hear me? Can you hear me?
Yes.
Yes, we have you now.
I'm so sorry. I seem to have various technical glitches with my computer, and it suddenly became too hot for whatever reason, probably listening to the other speakers. It was so excited it turned itself off, which didn't help at all. So apologies for that. And I hope that I can stay with you for the remainder of this session. Thank you, first of all, indeed, for your kind introduction, John. And I have indeed various reasons for being here. In fact, I come at this in 3 different ways. First, by training, I am a shipbroker, and I've been involved in a number of cases since 1983 as an expert witness in commercial shipping. I'm not an engineer, I'm not a technician, I've not been at sea. I'm now sailed, I've not been an officer or anybody as senior as that at sea. I'm a land lover. Nevertheless, I know something of how shipbroking works and putting commercial deals together, and obviously creating charter parties also means that I need to have understood the law, which I've studied, but I'm not able to call myself, and I'm not willing to call myself, a lawyer, and that's precisely why I have been appointed as an arbitrator since 1994 in London under LMAA, and more recently in Singapore with the SDMA. I'm appointed precisely because I'm not a lawyer, because I come to cases with my commercial background. In that way, I've therefore also come across a lot of expert witnesses who've appeared before me and others on the tribunal, and there are some good ones, and frankly, there are also some less good ones. And it's pretty simple to work out fairly soon who is simply bluffing and who really knows his or her subject backwards. And that is a lesson which is certainly to be well noted, particularly after Mark's correct comments. The third area of my involvement with this as an expert witness is also as chairman of the Baltic Exchange Expert Witness Association, known as BEWA. And in fact, that is why I'm wearing yellow and blue, not only for solidarity with Ukraine, but this is the Baltic logo on my tie. BEWA is an association of either very experienced expert witnesses, including Jonathan and quite a few others, Captain Keith Hart, who also contributed to this splendid book. And there are roughly 35 or so who are experienced, and another approximately 40 members, and we are growing globally, who are aspiring expert witnesses who may know something about the subject, but have not yet had the experience of being an expert witness, and there is a huge difference. And one of you may have mentioned this while I was unfortunately offline, so forgive the repetition if it is indeed repetition of somebody else's comment. There is a world of difference between being an expert and being an expert witness. One comment which was made earlier, quite right, David Pocket, you're absolutely right, that if you're not nervous, you're doing something wrong. You need to be aware of your obligation to a tribunal or to a judge, of course. And likewise, clearly in Jonathan's case, to a mediator who may well call, or maybe it's one of the parties may call an expert witness to boost their particular argument or issue. So as BEWA, we have aspiring expert witnesses, so aspiring members, and those who are more experienced. This is all under the umbrella of the Baltic Exchange, which of course is well known to almost every listener to this webinar. My own experience as an expert witness has been quite varied since 1983 with container ships, some with commercial broking, some with the meanings of various abbreviations when used by the shipping fraternity. And in fact, in one case, and David Pocket will forgive me, I hope, for mentioning the case, the Brillianto Virtuoso, with whom he, of course, or rather, there was the ghastly bomb under a car when a surveyor asked too many questions in Aden about this particular case, which turned out to be a massive fraud worth something in the region of $100 million. And I was brought in as one of 11 expert witnesses on one side, and there were 11 of us equivalent on the other side. Unfortunately, the expert witness who was called into the particular issue for which I was appointed, fortunately, he agreed with me. So it wasn't an issue, and we didn't need to appear in court nor to be cross-examined, although I was certainly prepared and ready to be so, to be cross-examined if necessary, because I knew that particular side of the subject. I would not put myself forward as an expert witness in other matters in which I am not an expert. That would be both foolish and frankly, I think also dishonest. So I need to be professional at all times. We have under BWA membership that is around the world, and if anybody's interested, of course, I'm quite sure you can look us up if you wish. I am certainly recommending and have already recommended this second edition of the book to all BWA members in a message to all members, which I sent round last week. And no doubt you will have, I'm sure, quite a few orders for the book from our 70 plus members. This is a work of great value and absolute necessity. Again, I apologize for having been offline for a while. If you have any other questions for me, I'd be happy to answer them.
Thank you very much, Jeffrey. We must press on. It's always difficult when you're with a lawyer and asking him to be brief, but I'm going to ask Charles. Charles and I go back quite a long way. I have to say, mainly in the course of the TSS luncheon organisation. But Charles is very experienced, and I'm going to ask him just to say a few words and take over the floor for just a few minutes. Charles, thank you.
Well, John and Bridget, first of all, congratulations on the publication. I think it's brilliant. I've learned a lot, and I intend to say nothing that adds to it at all. But what I will say is just a little point about the value of, one of the values of arbitration is the differences you have in experience sitting on the tribunal. The courts can't really match that at all because they've all got firsts honour degrees at Oxford and Cambridge, and haven't had much time to do anything other than the law, although there are exceptions. I would illustrate the importance of having some form of expert, not necessarily in the precise area that the case concerns, but somebody with technical qualifications on the tribunal. One involved an arbitration in a civil law jurisdiction, not a million miles from Dover, where the issue concerned a serious crane collapse on a vessel. And the crane was, of course, operated by charterers' stevedores. And the owners had an expert who was Swedish and spent all his life, he was early 60s, designing and building cranes and checking on their operation. And you know, he knew the subject brilliantly. His report was superb. And just before the arbitration hearing, we were informed that the charterer's expert had decided to withdraw his report, or rather charterer's lawyers had decided that he wouldn't be called and they would not rely on his report. Now, we thought we were home and dry. And I think in London, such a feeling of optimism would be justified. Lo and behold, the tribunal of 3 arbitrators sat on the papers for quite a few months, and then came up with their own theory of what went wrong. Now, that was a theory that had not been put to the expert, who'd bothered to come all the way from Sweden to give evidence orally, and it had not been put in any way to the owners before or during the hearing. So it was a clear breach of natural justice, one of the tenets of which is that the deciding tribunal cannot adopt something that a theory or an argument that has not been put before them, particularly on the facts. My other experience was in New Orleans, a case where a large amount of residues in an oil cargo couldn't be pumped ashore from an unheated vessel. And after a period of some 6 months, the judge, so this is not an arbitrator, but the judge came up with his own theory about how this could have been dealt with. He had no technical background, and the theory he put forward, which was the foundation for his decision, was not one that had been advanced at all by the charterers or indeed by the owners, experts. So there was all-round astonishment, particularly when it was quite obvious that his theory would not have worked in practice. Another example of a breach of natural justice. Would have been fine if he had put that theory to the parties before making up his mind and given them a chance to comment. Now, I'd like to think those episodes couldn't happen in London arbitration, but it is an example of where, had there been someone with some expert knowledge on the technical side on the tribunal, I can't believe that would have happened at all. So I would urge experts of any sort to give serious thought to becoming arbitrators. They may feel they know nothing about the law, but they will learn most of what is important about the law, particularly the law of procedure in arbitrations, very quickly. And their contribution cannot be underestimated. Thank you.
Well, thank you very much, Charles. And just before we press on, I'd just like to thank all the panel here today, because it added an awful lot to the book launch. And I do accept David Pockett's issue about being nervous before we give evidence. And I know amongst the people attending this webinar, there will be 1 or 2 who have gone through their masters or chief engineers oral exams. And I can assure you, going into the witness box is every bit as challenging. And as David said, if you're not nervous, you're not doing the job properly. Now, from here on, I'm going to hand over to Bridget just for a minute, but again, my thanks to you all.
Yes, and I would like to add my thanks as well. I certainly think that people hopefully listening in now have a better idea of what is involved in expert witnessing if they haven't been involved up to now. And really, our next poll is aimed at those of you who have not been an expert witness so far. Would you now consider this, should you be requested to help out in the case? Do let us know what you think. And in the meantime, while you're voting, let's have a look at the questions that we have got. John, I don't know if we want to direct some of these. I expect some of the people who are here today have got some questions, but we've got some practical questions here. could we direct? Is a witness allowed to change or modify a statement upon initial record? How do you think?
I'm not sure precisely what is meant by that, but once the expert report has been submitted, the next situation is you see the opposition expert's report, and that's when you might wish to change what you've said. Indeed, it's where you should change what you said if the other side have come up with a good argument. So it's not simply a question of changing something. I mean, the cross-examining barrister would love it if you changed things and crumbled your case. So it is a question of procedure, in my point of view.
And this is explained fully in the book, isn't it?
And the book covers that point.
Yeah.
How are we doing with the poll result?
Right, John, there you go. 76% would consider being an expert witness. So you've sold them well, despite David Pockett's comments, and 24 no. So there you go. And before we go, can I just remind everybody that the book is available with a 40% discount. If you, in the download area, you can get a brochure about that, or I've just put it on screen. Right, so John, another question that's come in from the audience, and this is from Clayton, and it says, what has been your experience, this is for the whole panel, what has been your experience been with the use of maritime simulation in expert witness testimony, and indeed the use of simulation in accident recreation for tribunals in general? Thank you.
Well, if you're asking me to answer that, it's going to be quite difficult because I'm too out of date to look at simulation, especially in the modern context, and reconstruction. I mean, I remember, and this is swinging the lamp, when digital photographs were treated with a great deal of suspicion because they could be doctored. And at that time, people didn't appreciate that a good digital analysis of the photograph would soon determine if that photograph had been tampered with, shall we say. So I think simulation is outside my personal experience, but David Pocketmouth or Zareen Rani may have some comments to make on that. David, first.
Well, although I don't use it myself, but MADAS, and it's certainly become accepted now, I think, as a very good program in front of tribunals and courts. And I think they are accepted simulations, provided they sort of properly verified. And I think they have been found to be most helpful. So that's my experience. Whether Jonathan or anybody else has got anything to say on that, I don't know. But I think simulations are now the in thing today. There's been an awful lot of research gone into them, and I think the results have been proved, I think, in court. I can't think of the case, but there was a case fairly recently where the simulation of a collision was accepted by the court, and you know, I don't think anything wrong with them as long as they are, you know, highly approved. And MADAS has been accepted, I think, internationally.
Yeah, I think one of the incidents with simulation is everyone assumes that they'll do away with the expert. I think quite the contrary is going to be the case, because simulation can be challenged by an appropriate expert. Now, there's possibly the youngest member of the panel is Captain Zarir Irani. Have you got experience of the use of simulation in analysis?
Thank you very much, John. I agree with David simulations are more and more acceptable and Madras based. But my experience is that if they are done without a peer review or without having any track record of these being used, they can actually bounce back, because although they are based on AIS data and the voice recorder on the bridge is used, the VDR, etc. There is more often than not a bit of doubt on how the representation is done for the understanding of the tribunal. But saying that, it is simplifying the pictorial view and the animation of what actually happened at IC, especially involving navigation incidences, or who said what when. We were involved in a very famous case, the Kashmir and Sina Saman, and we used that quite significantly to prove what happened when we were acting independently for one of the parties. Appointed by one of the parties. I shouldn't say for one of the parties. Saying that in today's electronic world, it is only going to be more and more significant to have reliable representation of electronic data, verifiable and transparent data, which is out there. So there is going to be a lot written down about how the data is interpreted, and that has to be made available and transparent. Saying that, the old notebook and the handwritten notes collected by an independent surveyor still is, I feel, the trump card of all those naysayers or all those doubting, provided it's written in legible English or any other language of that sort.
Thank you very much. Thank you, Maria. We're just about out of time, but again, can I thank our contributors to the book, and especially the panelists who've joined in this morning or this afternoon, depending where you are. It's been a great privilege for me to have such backing from a very good team. And I look forward to seeing how the book gets on when it's published. And I've no doubt, as the day goes on, lunch will prevail. But on that note, I'm going to say thank you to everybody who attended today. Again, all the panelists, a lot of old friends amongst you, and I will take this opportunity of standing down and passing back to the Nautical Institute.
Thank you very much, John. And can I say as well, thank you very much for your efforts in marshalling this series through. It's been a great pleasure to work with you and with everybody, not just all the authors, although very much so, because they have put so much of their expertise and enthusiasm into the books, but also the peer reviewers who have helped us establish that what we are writing is best practice. And I would urge people who are interested, either because they are doing it now or because they anticipate that they might well be called as expert witnesses, to buy the series and to gain from it. There's been a lot of generosity shown on behalf of the authors, who are very keen to help people understand and become better, which of course is a theme of the Nautical Institute. We do try to help people to expand best practice, to embrace it, and to support one another. So if you're not a member, I do urge you to join and benefit from that. We are celebrating our 50th anniversary this year as an institute, and we are looking ahead to the next 50 years. And I'm sure that whatever happens and however hard we try to make sure that everybody is following best practice, unfortunately, expert witnesses will still be needed for the next 50 years. So I hope that we can see people at our events around the world as we celebrate that. And I thank everybody for their participation today. All the best to everybody. Thank you very much.
Thank you, Bridget. Thank you, Captain Noble. Just on a final note, we have had some comments in that discount code may not be effective just now. We're working on that. So if it doesn't work for you right now, just wait just a moment and we'll get that working. So thank you very much. And on the final note, David Pocket, I have somebody who's written in about the importance of mentoring in preparing people for expert witness work, and they named you as a mentor, and the fellow's name is Captain Andre Legubin. So on that note, Bridget's already sold the membership, but we are a membership organization, so please join. Thank you very much.
Thank you, everybody.
Thank you.
And goodbye.